This is Barry Zalma speaking on Zalma on Insurance, a YouTube channel. I am a lawyer retired from the practice of law who now spends 100% of my time as an insurance claims consultant and expert witness, as well as an author. Today I'd like to talk about insurance being a contract of personal indemnity. The insurance claims adjuster must always ascertain that the owner or a person with some other insurable interest in the property that is the subject of the insurance is the person insured, and that the person insured has an interest in the property. Failure to do so could result in the insurer paying the wrong person or paying a person with no right to the benefits promised by the policy. Proceeds of a policy upon the interest of an insured are not subject to the claims of others who have an interest in the property but are not named as an insured, or who do not qualify as insureds by definitions contained within the policy. A first-party property policy is considered by the courts who have been asked to interpret the conditions of the policy a contract of personal indemnity. It is a contract made with the individual who seeks protection against the risks of loss to his property. The insurance does not go with the property as an incident thereto to any person who may buy the property. If it goes at all, it goes as a matter of contract for the transfer of the policy. The contract of insurance is also purely personal. It's a personal contract between the insured and the insurance company, and does not attach to or run with the title to the insured's property, absent an agreement for the transfer of the policy, and that agreement must be made between the insured and the insurer and the new owner. It is an elementary principle of insurance law that fire insurance is a contract that is personal, not one from which a profit is to be realized. The right to recover must be commensurate with the loss actually sustained. For example, in practice, consider a fictional Mrs. Jones, who is allowed to live rent-free in a home owned by her children. Mrs. Jones purchases in her name alone a policy of homeowners insurance, insuring her against the risks of loss to the structure and its contents. If a fire destroys the house, Mrs. Jones can recover because her interest in the house is an insurable interest, that is, an interest where she is damaged as a result of the loss of the property. Mrs. Jones' children, however, the owners of the home, also have an insurable interest in the home but are not insured under Mrs. Jones's policy and may not recover any proceeds from her policy. In California, as in most states, in common parlance we speak of a house as being insured, but strictly speaking it is not the house, but the interest of the owner that is insured, and whether that interest is founded upon a legal title, an equitable title, a lien, or such other lawful interest therein as will protect a direct and certain pecuniary loss to the insured by its destruction, he who has an insurable interest therein may recover under the policy, and only he who has an insurable interest in the property. Only a person who is both an insured and who has an insurable interest may obtain indemnity from a policy of first-party property insurance. For example, in Russell v. Williams, the California Supreme Court stated the rule as follows, quote, It is a principle of long standing that a policy of fire insurance does not insure the property covered thereby, but is a personal contract indemnifying the insured against loss resulting from the destruction of or damage to his interest in the property. Close quote. The property is not insured against destruction. The insured is guaranteed against loss to the extent of his insurable interest not exceeding the amount stipulated by the policy. As the betterment and improvements installed in the building pass to the owner at the expiration of a lease, in part consideration for the rent, the tenant could not sell them or remove or recover their value. It is, therefore had a limited insurable interest, the right to use them until the expiration of the lease, while the owner would have a 100% insurable interest in the property. In that way, consider Lighting Fixture Supply Company versus Fidelity Union Fire Insurance Company and Grange Mutual versus Central Trust Company. As a contract of personal indemnity, the policy only insures the person named in the policy against certain risks of loss of property in which that person has an interest. A person who has an interest in the property but is not named as an insured cannot recover under the policy. Similarly, a person named on a policy who has no interest cannot recover. No one can recover indemnity on a first-party property policy unless they have both an insurable interest in the property and are named as an insured or by definition are an insured of the policy. This talk about insurable interest and the fact that an insurance policy is a contract of personal indemnity has been adapted from my book, Zalma on Insurance Claims, 2nd edition, Volume 1, a 10-volume work on insurance claims available to anyone from Amazon.com as both a Kindle book or a paperback.